She was the one who claimed she had a contract with plaintiffs, and yet there is no such contract, and plaintiffs were nowhere near where the alleged harassment/retaliation took place. Lively knew this, and it is not the case that she was harassed by some masked stranger who turned out to be the plaintiffs. Neither could they have breached a contract with Lively because no such contract exists. I heard she doesn't like to sign her contracts, so even if there was one. What's up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. My name is Neidigh. If you've been following my channel, you know I've been covering the Justin Baldoni versus Blake Lively saga. Today, Blake Lively was hit with yet another lawsuit. Now, luckily, this one won't take 6 hours to get through because it's relatively very short. So, the plaintiffs are Jed Wallace and Street Relations Incorporated. Blake Lively is the only listed defendant here. It says complaint for declaratory judgment and defamation to the Honorable Court. Jed Wallace and Street Relations Incorporated, collectively plaintiffs, bring this action for declaratory judgment and defamation against Blake Lively, and would show as follows. 1. The parties. Wallace is a citizen of Texas and resides within the Austin Division of the Western District. He owns a company, Street Relations Incorporated, which is a crisis mitigation firm engaged by clients to help navigate real-life human crisis, threats, trauma, and mental health concerns. It helps primarily families and individuals when they find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situations. Street is a corporation organized under the laws of the state of California with its principal place of business in Texas and is therefore a citizen of a state other than New York. Lively is an actress and entrepreneur and is a citizen of New York. Factual background. On December 20th, 2024, Lively filed a complaint of employment discrimination before the State of California Civil Rights Department. The CRD named Lively as complainant and Wallace and Street, among others, as respondents, and alleged that they engaged in a variety of conduct in violation of California Government Code Section 12940 and Title VII of the Civil Rights Act of 1964. The CRD complaint went on to allege that plaintiffs' conduct includes sexual harassment, retaliation, failure to investigate, prevent, and/or remedy harassment, and aiding and abetting harassment and retaliation. Exhibit 1, the CRD complaint, attached hereto and incorporated herein. So the CRD complaint was the first filing that I went over when I first started discussing these cases at all on my channel. If you haven't seen it yet, you can go back and watch that stream. 6, the CRD complaint also asked politely to please see attached complaint for specific details. The attached complaint, which we attach and incorporate as Exhibit 2, has been described as a precursor to a lawsuit, although it had all the indicia of a standalone legal complaint. Indeed, some media subsequently published the precursor under the headline, "Read the Complaint." The precursor named Wallace and Street as defendants and sought damages for 1. Sexual harassment under California and federal law, 2. Retaliation under California and federal law, 3. Failure to investigate, prevent, and/or remedy to harassment under California law, 4. Retaliation under the California Labor Code, 5. Aiding and abetting harassment and retaliation under California law, 6. Breach of contract, 7. Intentional infliction of emotional distress, 8. Negligence, 9. False light invasion of privacy under the California Constitution, and 10. Interference with prospective economic advantage. Oh, was that all? On the same day the CRD complaint with the precursor attached was filed, the Civil Rights Department issued Lively a right to sue letter. Lively or her agents provided the precursor to various media entities for out-of-court republication, and because of the allegations contained therein, it made headlines around the world, according to Elle magazine, which linked to the precursor document, as did many other media. The precursor was followed on or about December 31st, 2024 by a formal suit in the United States District Court for the Southern District of New York. Wallace and Street were widely reported to be defendants in the formal lawsuit, although they were not, the confusion having been sown by the precursor. As Lively later admitted, she knew of no facts to support the allegations against Wallace or Street. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged sexual harassment, retaliation, failure to investigate, or aiding and abetting the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no such contract exists. Well, I heard she doesn't like to sign her contracts, so even if there was one. And they were not involved in any of the events depicted in either the precursor, where they were named as defendants, or the formal lawsuit, where they were not named, which could give rise to a duty towards defendant negligence or any other tortious conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. God, this is a mouthful. Then, on January 21st, 2025, Lively filed her verified petition for Rule 202 deposition in Hays County, Texas, against Wallace, but not Street, alleging, on information and belief, that Wallace was a subcontractor to a company called TAG to assist them in their unlawful retaliatory social combat campaign against Lively. The 202 petition conceded that Lively has no facts supporting the allegations she made against Wallace and Street in the precursor, which made headlines around the world, as she now, apparently under the threat of sanctions from one of the plaintiff's attorneys, sought to investigate the scope of Mr. Wallace's conduct. According to the Hays County online court records, Lively non-suited her 202 petition today. The 202 petition was a transparent attempt to chill plaintiffs' free speech rights and would have been fodder for a motion to dismiss under the Texas Citizens Participation Act, Chapter 27, Texas Civil Practice and Remedies Code, anti-SLAPP statute, whose purpose is to encourage and safeguard the rights of persons to speak freely. The statements of fact, actual or implied, of and concerning plaintiffs in the precursor and CRD complaint are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and special damages through emotional harm, Wallace, actual damages and real and projected loss of business, Wallace and Street, in an amount that exceeds $1 million. Jurisdiction and venue. This court has jurisdiction under 28 U.S.C. 1332 because the matter exceeds the sum or value of $75,000, and Wallace and Street, as plaintiffs, are not citizens of the same state as the sole defendant, Lively. This court may exercise personal jurisdiction over Lively because she has availed herself of the forum by filing a Rule 202 petition in Texas on the subject matter of this suit. Oof, that was a bad move. In addition, her defamatory statements were aimed at Texas, where both plaintiffs reside, and they undoubtedly caused harm in Texas. Venue is proper because, as Lively alleges in her Rule 202 petition, a substantial part of the underlying events that would give rise to the claims being investigated occurred in Hays County, part of the Austin Division of the Western District of Texas. In addition, a defamation plaintiff is accorded, I don't know if they meant afforded or accorded there, great deference in his choice of forum, especially when it is his home venue where the defamation is most keenly felt. That meets the standard for venue under the venue statute. First cause of action, Declaratory Judgment Act. The Declaratory Judgment Act allows a court to conclusively adjudicate and declare the rights and other legal relations of any interested party seeking such declaration. The purpose of the Declaratory Judgment Act is to afford one threatened with liability an early adjudication without waiting until his adversary should see fit to begin an action after the damage has occurred. The Fifth Circuit has long recognized the validity of such anticipatory declaratory judgment actions. As explained above, Ms. Lively has alleged 10 different causes of actions against Wallace and or Street, although she now admits that the CRD complaint and the precursor, which caused great harm to plaintiff's business by way of lost business, exceeding the threshold monetary limits necessary for diversity jurisdiction, as it was reported around the world, was without factual support, even though she now, belatedly, attempts to obtain some through her 202 petition. This claim is justiciable, and the court has authority to grant the relief plaintiffs seek, which is that 1. They did not breach any contract with defendant for the reason that, among others, no such contract exists. 2. They did not engage in any acts of harassment, retaliation, failure to investigate, prevent, and or remedy harassment, or aid and abet the alleged harassment or retaliation for the reason, among others, that they were not even present or otherwise involved in the events giving rise to the alleged harassment, nor did they have contemporaneous knowledge of the alleged events of harassment or retaliation. And 3. They did not have a duty to defendant which would give rise to a claim for negligence. And 4. They did not engage in any tortious conduct towards defendant. Plaintiffs seek a declaration pursuant to 28 U.S.C. Section 2201. Second cause of action, defamation. The precursor and CRD complaint named Wallace and Street as defendants or respondents and falsely stated that they had engaged in 10 illegal acts under state and federal law. Neither the precursor nor the CRD complaint were privileged because, among other reasons, they were provided by the defendant or her agents to third parties, including many media outlets. Defendant knew or should have reasonably anticipated, indeed she hoped, that these allegations would be republished around the world. As a result, defendant is responsible for republication damages. The statements of fact and concerning plaintiffs in the precursor are false and defamatory. They are made either negligently, if plaintiffs are private figures, which they are, or with actual malice, if plaintiffs are public figures, which they are not. The statements have caused, both by the original publications and the republications around the world, great harm to plaintiffs, and such damages are presumed if some or all of the statements are defamatory per se, or per quad, if not per se, and in any event exceeded $1 million. In considering whether the $75,000 jurisdictional amount has been reached, the court can take notice that many recent awards, Freeman and Moss v. Giuliani, $148 million, or settlements, Dominion/Fox, $787 million, Trump/ABC, $15 million, far exceeded that amount. Although Lively is a public figure, Wallace and Street are not. Thus, plaintiffs need to prove only negligence to establish liability. However, plaintiffs also seek punitive damages in an amount of not less than $6 million, and to satisfy the evidentiary burden in establishing the right to such damages, they must demonstrate actual malice. That is, that Lively either knew the allegations were false at the time she made them, or she acted in reckless disregard of the truth. That is, she had a high degree of awareness of falsity and in fact entertained serious doubt about their truth. She acted with actual malice because she was the one claiming to have been harassed and retaliated against. She was the one who claimed she had a contract with plaintiffs, and yet there is no such contract, and plaintiffs were nowhere near where the alleged harassment/retaliation took place. Lively knew this, and it is not the case that she was harassed by some masked stranger who turned out to be the plaintiffs. She knew and knows that they were not the harassers/retaliators, but made these allegations anyway, leaked them to the press, hoping they would be widely republished, which they were, but then excluded plaintiffs from the formal lawsuit, knowing they had nothing to do with the events depicted therein. 4. Jury demand. Plaintiffs, under Federal Rule of Civil Procedure 38, demand a jury. 5. Prayer. Plaintiffs therefore respectfully request that this court to enter a final declaratory judgment under 28 U.S.C. 2201 as requested, supra, and award damages for plaintiffs' loss of reputation and for further relief at law or in equity as to which plaintiffs may be entitled. And just to look back at this was the CRD complaint, and you can see she did name Jed Wallace and street relations there. This was Exhibit 1. Exhibit 2 is the precursor, so we're not going to go through all that again because we've already read the whole thing on a different stream. But again, you can see, where is it? Jed Wallace and Street Relations Incorporated are listed there. Exhibit 3 was the right to sue letter, and you can see right here in the complaint of employment discrimination, Jed Wallace and Street Relations, Inc. And then finally we have the Elle Magazine article, Exhibit 4, every explosive detail from Blake Lively's lawsuit against Justin Baldoni. And they even get ads into the PDFs on these things? That's crazy. Go away. I'm trying to read. It's a legal document. I guess it's just a screenshot. I don't know. I just can't get away from these ads, man. And here it says, who is Blake Lively's lawsuit against? You can see again, Jed Wallace, publicist, and Street Relations Incorporated, Jed Wallace's agency, are both listed here. So this is actually saying they were named in the actual formal lawsuit, which was, I don't believe, the case. The reputational damage is done nonetheless. Alright guys, like I said, that one was much shorter than the others. I'll continue to cover this stuff as it comes up. If you want to check out the documents yourself, you can go to courtlistener.com and you can find them that way. Or you can go on Pacer, and I can show you guys how to register for a Pacer account. The reason I like Pacer is I know you have to pay like 10 cents per page or whatever, so if you're just going to follow this case, maybe just go to Court Listener and get it. It's like, first of all the cases that I follow, not all the documents are on Court Listener, so I do have to download some of them from Pacer. And then second, I noticed that sometimes the Pacer documents are available, quite a bit sooner. Alright, thanks everybody. I appreciate you watching. Please hit the like and subscribe for me. It really helps my channel out a lot. New episode of the Court of Random Opinion podcast will be out on Friday.